In Chapter 3, we will explore criminal laws as they relate to fire departments, EMS agencies, and their personnel. Once completed with this module, you should be able to define crime and explain the goal of criminal law, identify and describe the types of crimes affecting fire and EMS personnel, explain the defenses to criminal culpability, and further explain criminal procedure. To frame this chapter, the textbook includes a scenario where you are an EMS provider testifying at a criminal trial based upon the treatment you provided to the victim of a crime. Unfortunately, while you still remember the call, the details are somewhat fuzzy, your documentation was arguably lacking, and the defense attorney is attacking your competence as an EMS provider given your poor documentation. In this case, your documentation is the victim's patient care report. How important is your documentation in a criminal prosecution case? What duty does a firefighter or an EMT have to assist law enforcement in their investigative process? What happens if a firefighter or EMS provider moves or displaces evidence at a crime scene? If a firefighter or EMT sees evidence of a crime while in a person's house rendering medical care, do the police need a search warrant to collect that evidence? Do patient confidentiality laws prohibit EMS providers from sharing with the police incriminating statements made by a patient? Are there instances where firefighters or EMS providers could be guilty of a crime while performing their duties? These are just some of the questions related to criminal law that may arise during the course of providing fire prevention and suppression activities or EMS services. When completed with this module, you should hopefully be better versed to respond to these and other similar questions. Unfortunately, by the very nature of the job, firefighters and EMS providers are often witnesses to various crimes, such as battery, sexual assaults, and child abuse. In other cases, they can be victims of crimes, such as a firefighter injured by an arsonist's intentional booby trapping or an EMS provider attacked by a violent patient. Occasionally, emergency service workers lose their moral compass and commit crimes themselves. Given these different aspects of how criminal laws impact firefighters and EMS providers, they may find themselves providing statements to the police or witness testimony in court. They may be victims themselves, or they could be processed within the criminal justice system as alleged perpetrators of a crime, which may also have profound implications for the agency that employs them. Before delving into too many details, we should take some time to define just what a crime is under the law. Simply stated, a crime is a social harm that the law makes punishable. True, when a crime is committed, there is often an individual who is the victim of the crime. Despite this negative impact to a single person, however, there is also a harm to society in that criminal conduct tears at the fabric of our structured society. Essentially, our society needs people to abide by certain codes of conduct or behavior for the benefit of everyone within the society. With that being said, not all bad conduct is illegal, which is why the second key component of the definition of a crime is that a law must be broken by the alleged perpetrator's bad conduct. Given the harm to society that results from criminal conduct, the goal of enforcing criminal laws is to limit or reduce the amount of harm suffered by society given the wrongful conduct of others. If found guilty of committing a crime, the criminal justice system punishes the wrongdoer. This punishment is believed to work to various degrees based upon 4 different mechanisms: deterrence, rehabilitation, restraint, and retribution. One of the reasons crimes are punished is to deter others from committing similar crimes. The thought is that people will not perform some bad acts because of the negative consequences they may face for such behavior. Essentially, knowledge of the potential sanctions or punishment for committing certain bad acts will prevent some people from conducting such acts. A very simple example of deterrence is the fear of a speeding ticket that deters some from exceeding the speed limit. Given that example, however, it is also clear that deterrence does not necessarily work for everyone, or it works to certain degrees. Another theory behind punishing criminals is to rehabilitate the criminal so he or she has better options in the future and avoids similar conduct as a result. Essentially, most criminals serving jail or prison time will be released back into society, and it is in society's best interest to ensure that person is rehabilitated by learning a skill set that allows him or her to integrate into society as a productive citizen. Such rehabilitation programs include counseling, rehabilitation, formal education, and job skills training. If a particular bad person is in jail, he or she is no longer out in society to commit more crimes. That is the premise behind the criminal punishment theory of restraint. The criminal is effectively restrained from committing additional crimes by virtue of his or her incarceration. The last theory of criminal punishment is retribution. By its very nature, the concept of retribution can be very controversial, as it arguably serves no legitimate societal benefit beyond a primitive need for revenge, or an eye for an eye, so to speak. On the other hand, it is not unusual for victims of crime, especially violent or invasive crimes, to argue that such punishment is well-deserved and just. Some may also argue that the fear of retribution may also serve as a deterrent, which takes us back to the first theory of punishment that we discussed. Before a person can be punished for a crime, the person must first be proven to have committed a crime. This means the person must complete some bad act while also having the mental state required for the commission of the crime, often referred to as the bad mind. Thus, it is important to not only identify the elements of the crime, but the mental state of the alleged criminal perpetrator must also be assessed. Generally speaking, most states utilize the Model Penal Code or some derivative, which defines 4 different mental states associated with various crimes: purposely, knowingly, recklessly, and negligently. If a person purposely commits a crime, he or she is said to have the conscious desire to engage in the bad conduct or cause the end result. Knowingly is a somewhat lower threshold than acting with purpose. If a person knowingly commits a crime, he or she is practically certain that his or her actions will cause a prohibited result. A reckless mental state exists when a person consciously disregards a substantial and unjustifiable risk. The last possible mental state is to be negligent, which means the person should have been aware of a substantial and unjustifiable risk resulting from his or her bad actions. While we said that a bad intent must typically accompany a bad act for a crime to be committed, there are some crimes, referred to as strict liability crimes, whereby the perpetrator need not have any particular mental state to be criminally liable for bad conduct. With such crimes, the defined bad act is enough to give rise to criminal culpability. It is even possible to be completely ignorant of the law that was broken or the existence of a fact related to the crime and still be guilty of the criminal offense. As an example of a strict liability crime, having sexual contact with a minor is often illegal, even if the alleged perpetrator thought the victim was 18 years of age or older. As far as crimes are concerned, while there are crimes defined at the federal level, most criminal conduct is defined and prohibited by state law. There are model criminal laws that have been drafted by the American Law Institute, referred to in totality as the Model Penal Code, that have been adopted in part or in whole by many states. Other states have their own definitions for various crimes. Regardless of whether a state uses the Model Penal Code or not, there can still be significant fluctuation between the criminal laws in one state versus another. We will begin defining various crimes within the upcoming slides given the Model Penal Code definitions of the crimes. Given differences from state to state, however, it is important to be familiar with the crimes as defined within your particular state. We will begin our exploration of specific crimes from the top down, so to speak, with the crime of homicide. Homicide occurs when someone kills another human being. This means it is not a homicide if a person kills an animal. It is also not a homicide if someone attempts to kill someone who is already dead. Underneath the umbrella of homicide are the crimes of murder and manslaughter. At common law, murder occurred when one person killed another with malice aforethought. Malice aforethought included the intent to kill, grievous bodily harm murder, felony murder, and depraved heart murder. The Model Penal Code has since updated this definition to purposefully or knowingly killing another human being. Manslaughter is still a homicide, but it occurs without malice aforethought. There are historically 2 types of manslaughter recognized in criminal statutes. The first is voluntary manslaughter, where someone intentionally kills another person in the heat of passion with adequate provocation. This is the proverbial "I just saw red" argument, where a person is in such shock after seeing something disturbing that he or she momentarily loses all reason. The second type of manslaughter, involuntary manslaughter, occurs when a person negligently or recklessly kills another person. Under the Model Penal Code, manslaughter exists, but it is not split up into voluntary and involuntary. Rather, manslaughter is defined as either reckless homicide or a homicide that would be murder if not for the influence of extreme mental or emotional disturbance for which there is a reasonable explanation or excuse. As an EMS provider or even a firefighter, it is well within the realm of possibility that you will come into contact with the victim of an attempted homicide or may even declare someone dead who was the victim of a homicide. While good documentation is always important, such circumstances necessitate even more scrutiny of your documentation. Not only must the EMS provider or firefighter adequately, appropriately, and thoroughly document the event, but efforts must also be made to preserve potential evidence. In addition, because a criminal defense attorney may try to undermine the testimony of a firefighter or EMS provider at trial, it is important that firefighters and EMS providers function with the utmost integrity at all times. The last thing a prosecutor wants is to lose a criminal case because the EMS provider was shown to be untrustworthy by the defense. Theft is another category of crime that consists of multiple specific crimes. Generally speaking, theft occurs when someone takes another person's property without that person's consent. The broad crime of theft includes specific crimes like larceny, embezzlement, false pretenses or fraud, and robbery. Larceny is the unapproved taking and removal of the personal property of another by an individual who intends to permanently deprive the owner of that property. It is important to recognize that larceny does not include theft that occurs through force or the threat of force. That would be robbery. Embezzlement evolved out of the crime of larceny. Under embezzlement, it is recognized that the criminal suspect had permission from the property owner to possess the property at some time. At some point, however, the embezzler decided to convert the property to his or her own use, thus depriving the lawful owner of that property. This is a crime that is often seen in the employer-employee relationship, where the employee has the permission from the employer, either expressed or implied, to possess the property, and the employee then decides to take the property for him or herself. Fraud or false pretenses occurs when someone misrepresents a material fact to another person for the purposes of gaining a legal advantage by which to secure the property in question. While fraud can occur within different legal contexts, it is primarily associated with contract law and the buying or selling of property. As mentioned previously, larceny takes a step up in severity to robbery when property is taken from another through the use of force, intimidation, violence, or the threat of violence. Firefighters and EMS providers are usually held in high public regard. They are in positions of public trust and routinely have access to individuals' personal property at times when those people may be at their most vulnerable, like a family seeing their house consumed in flames while firefighters are working inside the structure, or an unconscious patient in his or her home. In this respect, it is absolutely critical for firefighters and EMS providers to have a high level of personal integrity. Stealing from the members of the public we are sworn to protect is not only morally and ethically wrong, but it is also criminal behavior that inevitably reflects poorly not only on the individual firefighter or EMS provider, but on his or her employer as well. Burglary is recognized as the illegal breaking and entering of a building for the purpose of committing a crime. Because the sanctity of an individual's homestead is involved, burglary is considered to be a worse crime than larceny, which typically means the punishments are more severe if convicted of burglary as opposed to larceny. Luckily for firefighters and EMS providers, burglary requires the intent to commit a crime when breaking into a residence. Because firefighters and EMS providers are occasionally required to force entry into a building, this distinction is an important one, thus insulating them from being accused of burglary for forcing entry into a residence. Many states also have laws that recognize the privilege of emergency service agencies, such as fire departments, police departments, and EMS agencies, to force entry into an individual's residence if deemed appropriate. With that being said, it is still important to ensure firefighters and EMS providers have a legitimate reason to force entry into a private dwelling or business. Keep in mind as well that some criminals will try to use the crime of arson, which we will discuss later, to cover other crimes such as a homicide or burglary. Firefighters in particular need to be aware of potential evidence of such crimes, such as evidence of forced entry before the fire department's arrival when responding to fires. Assault and battery are often discussed together, but they are indeed two separate crimes. Battery is the more violent or harmful of the two crimes, and is commonly defined as an intentional, unpermitted, harmful, or offensive touching or contact of a person or an object closely attached thereto. Criminalizing the conduct associated with battery recognizes the right of an individual to be secure and safe in his or her own personal autonomy. Assault, on the other hand, is often considered to be an attempted battery where no harmful or offensive touching actually occurred. At common law, assault was defined as placing someone in apprehension or fear of a harmful or offensive contact. If a person attempts to punch you in the face, you see the fist coming at you, but the punch misses, that is an assault. If the fist actually connects, the subsequent touching of your face with that person's fist is a battery. As far as assault is concerned, verbal threats in the absence of some type of physical manifestation of the threat are typically not considered an assault. Sticks and stones may break my bones, but words will never hurt me is the spirit of that requirement. There must be some imminent likelihood of a battery, that harmful or offensive touching, for an assault to occur. The victim must also be aware of the assault at the time it happens. Taking our punch example again, if the person tries to punch someone in the back of the head, misses, and the target victim never sees it coming, no assault occurred as the victim was never placed in fear or apprehension of the touching. The impact of battery or assault for firefighters and EMS providers is pretty easy to see. People have the right to be secure in their own bodies. If an individual does not want to be touched, then he or she has the right to not be touched. In the performance of fire and EMS duties, however, it is often necessary to touch others. The first thing to keep in mind is that the crime requires the touching or attempted touching to be harmful or offensive. Additionally, it is possible for someone to consent to a touching. Being tackled by a 250-pound linebacker can be very harmful to the human body, but other football players consent to that punishment by playing the game. Along somewhat similar lines, firefighters and EMS providers often rely upon the concept of consent, whether implied or expressed, when they interact with others. As consent applies in both the criminal and civil aspects of both assault and battery, and emergency workers are probably more likely to have issues with consent given civil litigation, consent will be discussed in greater depth later in the text. One other aspect to consider, for EMS providers in particular, is that we are often called upon to provide care and treatment to others who have been victims of battery. Proper documentation of assessment findings, including noticeable wounds and the patient's own complaints, are very important in assisting both law enforcement and the victim, our patient, seek justice against the perpetrator of the crime. Trespass is a crime that deals with a person's property, whether that be real property, land, or chattel, other personal property. The crime of trespass is defined as an unlawful intrusion that interferes with another person's property. As is common with many of the crimes we are discussing within this chapter, not only does this bad conduct, interfering with someone else's property, constitute a crime, but trespass also gives rise to a civil cause of action as well. Somewhat related to the legal implications of burglary, firefighters and EMS providers must routinely enter or even damage the property of another to perform their jobs. Examples would be forcing entry into a house, cutting a hole in a roof for vertical ventilation, breaching a wall to check for fire extension, or cutting apart a car during extrication activities. In other non-emergent contexts, such conduct would be a crime and also open the door to civil liability as well. To avoid complications associated with trespass, many states have laws that provide legal privilege to firefighters and EMS providers when performing such tasks as a part of their jobs, and it would be prudent for any emergency worker to acquaint himself or herself with such laws as they apply within his or her respective state. Returning to crimes that have a significant impact on an individual's personal autonomy, the definition of sexual assault can vary significantly from state to state. Generally speaking, sexual assault is defined as an unwanted or illegal contact of another person that is sexual in nature. While common law used to define sexual crimes by terms such as rape, groping, and so on, newer definitions recognize unwanted or illegal contact of a sexual nature as sexual assault with different degrees defined based upon the severity of the touching. The highest degree of sexual assault, first-degree sexual assault, which was previously routinely referred to as rape, involves forced sexual intercourse. The lowest degree of sexual assault commonly involves touching an individual's buttocks, breast, or genitalia over clothing. With that being said, the Model Penal Code defines numerous types of sexual crimes, and the definitions are somewhat outdated given modern thinking about crimes of a sexual nature. Things have changed a bit since the Model Penal Code provisions related to sexual assault crimes were drafted in 1955, and there have been discussions, at the time of production of this presentation, about updating the language considerably. For that reason, many states have laws that are arguably more comprehensive and modern than the Model Penal Code. As an example of how these laws have changed, rape used to be defined at common law as forced sexual intercourse by a man on a woman who is not his spouse without consent. Based upon this definition, it was not possible for a woman to rape a woman to rape another woman, or a man to rape a man. Additionally, it was not possible for a man to rape his spouse regardless of whether or not she consented to the sexual contact. Modern definitions include sexual crimes such as gross sexual imposition, deviant sexual intercourse by force or imposition, corruption of minors, seduction, sexual assault, and indecent exposure. As our societal values continue to evolve with regard to gender identity, equal rights, consent, and even the role of drugs and alcohol in such cases, these laws will continue to evolve as well. While the term statutory rape is an outdated term, the premise is still the same regardless of what a state's law chooses to call consensual intercourse with an individual younger than the age of consent. Such conduct is a strict liability crime where honestly not knowing the victim was under the age of consent is not a valid defense. From a fire and EMS perspective, it is unfortunately not uncommon for firefighters and EMS personnel to have to render medical care to victims of sexual crimes. In such cases, it is not only important to care for the patient, but to also be mindful of potential evidence that can assist law enforcement in pursuing the perpetrator's conviction for the sexual assault. This means documenting well and preserving evidence whenever possible. Aside from treating sexual assault victims, EMS providers routinely must examine and palpate patients based upon medical complaints or traumatic injuries. A paramedic applying a 12-lead to a female patient will routinely need to expose the woman's chest and may need to move or lift her breast to properly place the 12-lead electrodes. In these cases and others, communicating with the patient is important. Obtaining consent is critical if possible. Having more than one person with the patient can help avoid unwarranted allegations of EMS provider misconduct, and thorough and proper documentation is critical. Beyond these somewhat routine occurrences, there have also been cases where firefighters or EMS providers are themselves accused of crimes of a sexual nature. Whether such allegations relate to their positions as emergency service workers or not, substantiation of such claims undermine the public's trust in the profession as a whole, given the bad acts of a limited few. If you are an employer who finds himself or herself dealing with an employee accused of such misconduct, it is important to protect the organization while also being mindful of the accused firefighters or EMS providers' due process rights. Another crime that relates well to EMS in particular is that of false imprisonment. This crime occurs when someone is illegally confined against his or her will. Believe it or not, the length of the confinement and the area to which a person is confined are irrelevant to the commission of the crime of false imprisonment. Have you ever seen an EMS crew transport someone despite that individual's objections? That could be a problem if the patient truly had the capacity to make his or her own healthcare decisions and there was no intervening circumstance that would grant the EMS providers the right to restrain, detain, or otherwise imprison the patient on the scene, in the back of an ambulance, or anywhere else for that matter. Local protocols are important to assist EMS providers in navigating these murky legal waters, and such protocols should be drafted with the input of an attorney who has knowledge as to how laws in the specific jurisdiction treat detaining, restraining, or imprisoning a person in emergent scenarios. While cases related to false imprisonment are not very common, addressing this potential crime on the front end through well-drafted protocols will help protect your EMS providers against such charges. Kidnapping as a crime is essentially false imprisonment that involves moving the victim from one place to another. In some jurisdictions, false imprisonment becomes kidnapping once force, or even fraud in some states, is used. As with false imprisonment, the crime of kidnapping has direct implications to EMS providers who routinely transport people in an ambulance. Falsely imprison someone in the ambulance and transport that patient from one location to another, and kidnapping has arguably occurred. Again, EMS providers must remember that people within the United States have significant personal autonomy rights. Just because a patient may suffer harm by not being transported does not give the EMS crew permission to forcibly transport the patient if he or she is competent to make healthcare decisions and refuses to be transported. As previously mentioned, EMS agencies should have legally sound protocols, policies, or procedures in place beforehand to address how these cases should be addressed by their providers. While false imprisonment and kidnapping are crimes, there is also the potential for civil liability for these actions. Given that consent is a key consideration in the defense against such civil claims, we'll discuss these crimes as civil wrongs in greater depth later in the text. Switching gears from EMS to fire, the crime of arson was defined at common law as the malicious burning of the dwelling house of another person. This definition obviously had some problems, however, as it was not arson to burn your own house or a business property. Thus, current laws now recognize arson to include most structures. There is routinely a dollar amount threshold associated with arson statutes above which the crime is arson and below which the burning may not even be a crime, or it may be something else like disorderly conduct or another lesser crime. These current arson definitions will also commonly consider it a crime to burn one's own house given specific circumstances, such as an attempt to collect insurance money by claiming the intentionally set fire was accidental or not incendiary. The use of incendiary devices, including bombs and explosions, may also be included in arson statutes as factors to consider when determining the severity of the potential punishment associated with the crime. Obviously, firefighters are often the first individuals to respond to a burning structure or a vehicle. Firefighters must first and foremost be mindful of their personal safety, as arsonists will occasionally booby-trap the property to ensure the fire cannot be rapidly extinguished. As far as the crime of arson is concerned, firefighters should also be mindful of evidence preservation when conducting their duties. Be aware of your surroundings, note any unusual circumstances upon arrival or during suppression activities, and preserve any evidence found or collected at the scene. As arson is a crime that has direct and obvious implications to firefighters, we'll discuss the legal implications of conducting fire investigations later in this presentation. There is also a classification of crimes that occur as precursors to other crimes where wrongful behavior is performed before a target offense is committed. These inchoate offenses, or preliminary crimes, include attempt, conspiracy, and solicitation. Attempt of a crime occurs when the criminal defendant took a substantial step toward the target offense and was somehow prevented from completing the offense. An example would be an arsonist who attempted to start a fire but was thwarted by a flawed plan or poor execution. The mental state required for an attempt is the same as that for the target crime itself. If convicted of an attempted crime, the defendant receives a similar punishment but to a lesser severity. A conspiracy to commit a crime occurs when two or more people enter into an agreement to perform some unlawful act, and at least one of those people takes some type of minimum overt act in furtherance of that agreement. All co-conspirators are liable for all foreseeable crimes committed in furtherance of the conspiracy, and the conspiracy charge is pursued by the prosecution in addition to the charge of the target crime itself. Given our previous arson example, if the person was working with another to commit the arson, both people can be charged for any foreseeable crimes committed as a part of that conspiracy. The crime of solicitation occurs when someone asks another person to commit a crime with the intent of having that crime carried out. Even if the target crime is not committed, solicitation has occurred. In the previous arson example, as soon as one person asked the other to assist in the arson, the crime of solicitation had occurred. If the target crime, such as the arson in this scenario, is actually committed, the solicitation charge merges with the target crime. As with many of the crimes already discussed, inchoate offenses can impact firefighters and EMS providers in different ways. The example provided in the book discusses an EMS provider who is struggling with a narcotics addiction and approaches a fellow EMT to help him or her steal narcotics from the ambulance or service. In asking the fellow EMS provider to assist with the commission of a crime, solicitation has occurred. If the solicited EMS provider agrees, then you have a conspiracy. If they are unsuccessful, they could be charged with a conspiracy to divert narcotics, and the primary actor in the scenario, the one who asked for help, could also be charged with solicitation. If they are successful in their efforts, they could both be charged with conspiracy and the target crime itself, diverting narcotics. Those who assist others in committing a crime can also be found criminally liable for accomplice liability. At common law, accomplice liability was defined by the crimes of accessory before the fact, accessory after the fact, principal in the second degree, or principal in the first degree. Under the Model Penal Code, accomplices are simply recognized as principals in the crime. This means that the person aided, abetted, assisted, encouraged, enticed, helped, or lent some type of assistance to the criminal perpetrator. To frame accomplice liability within the fire or EMS disciplines, there are two primary scenarios that could arise. One includes criminal accomplice liability when a firefighter or EMS provider assists, encourages, or entices someone in committing a crime. Another scenario arises when a firefighter or EMS provider becomes privy to an illegal activity and then must decide whether or not to involve the police. A common scenario is when an EMS provider is attempting to treat someone suspected of taking an illegal drug or illicit substance. It is important for that EMS provider to know whether or not the patient took something, so it is not unusual for that provider to tell the patient he or she is not a police officer and simply needs to know what, if anything, was taken to better help that person. If the patient admits to using an illegal drug, not reporting that to the police does not make the EMS provider an accomplice, as that EMS provider did not aid, abet, encourage, or otherwise help in the commission of that crime. Keep in mind, however, that firefighters and EMS providers may be placed in a situation where the law requires them to report certain suspected criminal activity to the police, such as child or elder abuse, or specific types of injuries, such as gunshot wounds or stabbing injuries. In some states, depending on how the laws are written, failure to report when mandated to do so can result in some level of criminal culpability. As always, it is important to be familiar with the laws that govern this activity within your specific state and jurisdiction. If accused of a crime, the government must prove every element of that crime to obtain a conviction against the criminal defendant. Beyond relying on that burden of proof, there are times when the accused will make an affirmative defense to the crime. Such defenses include age, as in the case with minors under 18, 16, or whatever age is defined by the laws of the state, insanity, mistake of law or fact, necessity, coercion, self-defense, defense of others, or duress. In the case of firefighters and EMS providers, the defenses of consent and privilege would often be available if charges were levied for certain acts. Given the existence of consent or privilege, it is unlikely that a firefighter or EMS provider would ever find himself or herself as a criminal defendant where he or she would need to make either of these affirmative defenses, but we will still discuss them here. Consent is the first affirmative defense that would routinely be available to a firefighter or EMS provider accused of certain types of wrongdoing. If a person consents to your assessment and treatment, for instance, no battery occurs when the firefighter or EMS provider touches the patient, starts an IV, or delivers that violent cardioversion. One of the problems with consent, however, is that it cannot be used as a defense for some crimes. An example would be assisted suicide. Just because the person consents to someone else taking affirmative steps to help the suicidal person take his or her life does not mean that person is therefore immune to criminal prosecution for murder, manslaughter, conspiracy, or whatever other charges may apply to the circumstances. Consent can also be limited based upon what is reasonable. While I realize it is probably a horribly unrealistic example, and I'm probably dating myself with the reference, there was a Bruce Willis movie called The Last Boy Scout in which a professional football player, under tremendous pressure to perform as part of a point-fixing gambling conspiracy, pulled a gun out of his uniform and shot defending players so that he could score a touchdown, and thus hold up his end of the conspiracy. Again, I realize it is a crazy example, but bear with me. The defending football players have given their consent to a certain amount of physical punishment by playing in the game. This punishment could include concussions, broken bones, and numerous other types of trauma. Being shot by another player, however, probably exceeds the scope of that consent. Keep this thought in mind as we'll be back to it in just a second. As far as consent is concerned, there are two primary types used by firefighters and EMS providers to protect them from not only criminal prosecution, but civil liability as well: express consent and implied consent. Express consent occurs when the person literally tells you it is okay to do what you are about to do to him or her. Implied consent occurs when the person is fully or reasonably aware of what you are about to do and that person does not object, or when that person is unable to provide or withhold consent due to a lack of capacity, so it is implied that the person would want the firefighter or EMS provider to help. Coming back to our previous thought about exceeding the scope of consent, implied consent allows the firefighter or EMS provider to do what is reasonably necessary to help that person. It does not give the firefighter or EMS provider free rein to do whatever he or she wants to do beyond what is necessary to help. An example would be the alleged sexual assault of a patient who lacks capacity or is unconscious. If such an assault actually did occur, it is probably fair to say that the implied consent to help the incapacitated person did not include the consent to the sexual assault. Beyond consent, firefighters, EMS providers, and other emergency workers are routinely empowered by law to perform their duties. These laws recognize that firefighters may need to break things to do their jobs, such as breaching doors, breaking windows, cutting apart cars, cutting holes in roofs, and so on. EMS providers need to touch patients to conduct assessments and provide medical treatment. Ultimately, the utility provided to society as a whole by these actions are recognized as more important than an individual's personal autonomy or other rights. Given this background on crimes in general, we will now explore principles of criminal procedure recognized throughout the United States. First and foremost, a government-employed firefighter or EMS provider is considered to be an agent of the government. Thus, if the actions of a firefighter or EMS provider negatively impact or disadvantage a criminal defendant in violation of constitutional due process or other guarantees, that could undermine attempts to prosecute the person for the related crime, even if the firefighters or EMS providers' interference with those constitutional rights was inadvertent or unintentional. The first component of criminal procedure to be explored is the subject of effecting an arrest. Once a crime or an alleged crime occurs, a criminal defendant enters the criminal justice system by means of an arrest. Simply stated, an arrest occurs when that individual is seized or forcibly restrained, thus preventing that individual from enjoying his or her right to free movement within our society at that point of time. Occasionally, there are news stories about firefighters, EMS providers, and even private citizens who witness or suspect a crime and attempt to apprehend and detain the perpetrator until police can arrive. When that happens, those individuals are effecting what is known as a citizen's arrest. While a citizen's arrest is commonly recognized at common law and by the laws in many states, the problem is that these individuals are not police officers and, as a result, are not specifically privileged to the same extent as police officers to make that arrest. This means if a police officer arrests somebody and it turns out the police officer was wrong in doing so, the person who was arrested typically cannot sustain a lawsuit against the police officer for a wrongful arrest, as a good faith mistake on the part of the police officer is considered to be okay by society and our laws. We do not want police officers to have to second guess themselves on every arrest out of fear of being sued for making that arrest. In comparison, if a firefighter, EMS provider, or other citizen makes a citizen's arrest and it turns out he or she was wrong to do so, the person who was arrested could very well file a lawsuit against that person for battery, false imprisonment, or some other pertinent civil complaint. Additionally, if the case is egregious enough, the wrongful arrest could give rise to criminal culpability as well. In a scenario that is probably more likely, firefighters and EMS providers are routinely in positions where they may witness evidence of a crime. This can give rise to constitutional issues regarding the ability of the government to conduct searches and seize evidence of crimes. Essentially, the Fourth Amendment to the Constitution, as applied to the states by the 14th Amendment, guarantees individuals the right to be free from unreasonable governmental searches and seizures. As we will see shortly, this is an important fundamental constitutional right that firefighters and EMS providers must understand if employed with a municipal or governmental agency. The Fourth Amendment guarantee to be free from unreasonable governmental searches and seizures gives rise to something known as a warrant. There are two types of warrants we will discuss over the next few slides. The first is a search warrant, which is a written order signed by a judge or magistrate that authorizes law enforcement to conduct a search or seizure. To obtain a search warrant, the governmental agent, commonly the police, must have probable cause to believe that a criminal offense has been committed or is about to take place, and that specific evidence of that crime exists in the area to be searched. One very important and key word within the Fourth Amendment is the word unreasonable. Thus, there is no protection against reasonable searches and seizures, just unreasonable searches and seizures. The reasonableness of a search or seizure commonly turns on whether or not the person had a reasonable expectation of privacy in the place being searched. With this in mind, there are several recognized exceptions to the search warrant requirement. These exceptions are considered to be reasonable searches and include a search incident to a lawful arrest, the plain view exception to the warrant requirement, consent, a Terry stop, a stop and frisk, the automobile exception, and certain emergencies, such as hot pursuit or other exigent circumstances like a structure fire or medical emergency. Understanding the Fourth Amendment guarantee for people to be free from unreasonable governmental searches and seizures is important because if a mistake is made by a governmental agent and a search or seizure is determined to be unreasonable by a court, something called the Exclusionary Rule comes into play. The exclusionary rule prohibits the use of evidence obtained, seized, in violation of the Fourth Amendment. Depending on the piece or pieces of evidence impacted by the exclusionary rule, the prosecution may simply fall apart, which is both unfortunate and unacceptable, as that means justice may not be served due to a failure on the part of the government, which could include a firefighter or EMS provider, to abide by recognized constitutional protections and procedures regarding searches and seizures. Warrant requirements and their exceptions are very important within the context of fire origin and cause investigations. On their face, fire origin and cause investigations serve a very important societal function. As a society, we do not like it when buildings or property burn, or when people are injured or killed in fires. To prevent these events from occurring, it is important for us to understand what causes fires so that we can take steps to prevent them in the future. In this respect, a fire investigator typically does not need a warrant to conduct a fire investigation contemporaneous to suppression activities because at that initial stage, he or she is not seeking evidence of a crime. Rather, the investigator is trying to determine where the fire started, what caused the fire to start, and in so doing, how to prevent future similar fires. In conducting a fire investigation, it is important to recognize that such an investigation must occur contemporaneous to or shortly after suppression and overhaul activities are conducted or concluded. The longer the period of time from the conclusion of the fire department's suppression and overhaul activities, the less likely the court will apply the exigent circumstance exception to the warrant requirement. Since the textbook was published, there has been some feedback that prompted the need for additional clarification. First, the term cause and origin is used within the textbook when referring to the fire investigation process. This term was used by the United States Supreme Court in both the Michigan v. Tyler and Michigan v. Clifford decisions, which is why this term was used in the textbook despite the fact many investigators are now using the term origin and cause, as it is taught in fire investigation classes that the origin point of the fire must first be identified before a cause can be determined. For the purposes of this discussion, please consider the two terms cause and origin and cause to be interchangeable, even if emerging doctrine is to use the origin and cause moniker. Second, when conducting a fire investigation, if the investigator comes upon evidence of a crime, the textbook states the investigator must stop the investigation and obtain a criminal search warrant. Unfortunately, that statement may be an oversimplification of a complex issue based upon the Michigan v. Clifford Supreme Court decision. Keep in mind that the Clifford case involved the need to obtain an administrative search warrant to conduct a fire investigation, as the cause and origin investigation was removed from the exigent circumstances of the fire itself and the fire department's suppression and overhaul activities. We will discuss administrative warrants momentarily. For the time being, however, the court recognized that administrative warrants serve a specific purpose and, once evidence of a crime is discovered, that purpose changes, which necessitates the need to obtain a criminal search warrant. Part of the court's decision also identified the purpose of the investigation and recognized the need for a criminal search warrant once it was clear to the investigator that a crime had probably occurred and the investigation changed from a cause and origin investigation to a criminal investigation. Even when conducting a fire investigation as an extension of suppression and overhaul activities, this is probably an important distinction to keep in mind. So long as the investigator is attempting to determine the cause and origin, or origin and cause, of the fire, any evidence he or she finds during that administrative process is considered to be in plain view, which means it falls under the plain view exception. Once cause and origin is determined, additional searching for evidence of a crime should probably be conducted under the umbrella of a criminal search warrant, as the administrative function of determining origin and cause has been completed. Again, the textbook was written to provide awareness-level information regarding a wide range of legal topics that impact fire, EMS, and emergency services. Exploring the legalities that apply specifically to fire investigations, the Fourth Amendment, and warrant requirements can arguably be a book unto itself. When the textbook stated an investigator should stop a cause and origin investigation and obtain a criminal search warrant if he or she suspects a crime occurred, that was included to provide guidance that should stand up to virtually any legal challenge by a criminal arson defendant. Having that criminal search warrant makes the case very clear for a subsequent court examination of the facts surrounding that case. The textbook did go on to state that the exclusionary rule will likely impact evidence obtained as part of a criminal search related to a cause and origin investigation, but in saying so, the textbook did not say that was always the case, as this particular type of scenario is very factual driven and lends itself to various proverbial shades of gray. While I suspect this language will be further clarified in any subsequent update of this textbook, for the time being, please keep this information in mind, and if you are provided with specific guidance by law enforcement, a local prosecutor, or an appropriate attorney working for your agency on when to obtain a search warrant in the course of conducting fire investigations, you would probably be safe in following their advice. As just discussed, the second type of warrant we need to explore is an administrative warrant. An administrative warrant is commonly issued to administrative agencies with enforcement power to check for noncompliance with the law. A routine fire service example would be the conducting of fire inspections within the community. If a property owner refuses to allow a fire inspector to conduct an administrative inspection of the property, as commonly required by law, the inspector can obtain an administrative warrant by a court to conduct that inspection to verify compliance with building, fire prevention, and life safety codes. Administrative warrants are also recognized as being available to governmental bodies performing certain administrative functions, such as conducting an origin and cause investigation after extinguishment of a structural fire. As discussed briefly in the previous slide, administrative warrants have a very specific purpose. Unlike a criminal search warrant, an administrative warrant does not require probable cause. It is enough to show the need to comply with an administrative rule or function to receive an administrative warrant to enter another person's or entity's property. If, however, during the course of an administrative search, evidence of a crime is discovered, the governmental agent must halt the administrative search and obtain a criminal search warrant to conduct the search or investigation. We discussed in a previous presentation that case law is another source of law in the United States, and the recognition of Miranda Rights is a perfect example of case law that applies to the current discussion. Miranda Rights actually fall under the subjects of arrest and the Fifth and Sixth Amendments, which will be discussed momentarily. As another clarification, the textbook does state Miranda Rights cover the Fourth Amendment while omitting the Fifth and Sixth Amendments from the discussion. This was an error and an oversight that will need to be addressed in a subsequent edition if one is produced. If you ever watched Law & Order or some other crime drama movie or television show, you more than likely have heard someone read their Miranda rights to remain silent, that anything they say can be used against them in court, and that they have the right to an attorney. If a municipal firefighter or EMS provider ever finds himself or herself in a position where he or she is interviewing a potential criminal subject, understanding when Miranda warnings are required is important. Essentially, there are two elements that must exist before Miranda rights are required. First, the person of interest must be in custody, which means that person is being detained and is not free to leave. This is a subjective standard in that if the person was indeed free to leave, but he or she did not believe he or she was free to leave, then that person would be considered to be in custody for the purposes of determining whether Miranda rights applied to the situation. Second, there must be an interrogation. The person must be asked questions by the governmental agent. If the person is not asked any questions but simply volunteers information, Miranda rights do not apply. In most of these cases, law enforcement will probably be involved, which means they should probably take the lead in providing the suspect with his or her Miranda rights. It is not unheard of for a fire investigator or even a fire inspector to have a certain amount of criminal investigative authority, however, depending on the jurisdiction. There are also foreseeable scenarios where an EMS crew may have a person restrained in an ambulance and they begin asking the patient questions about a potential crime. As a result, firefighter and EMS provider knowledge of Miranda rights is probably a good idea, just in case. The Fifth Amendment stipulates, among other things, that a criminal defendant cannot be compelled to be a witness against him or herself. This amendment is one of the reasons for the Miranda rights we just discussed. Later in the textbook, we'll discuss drug and alcohol testing of employees. Many have made the argument, unsuccessfully I might add, that using blood or other fluids against the person constitutes a violation of their Fifth Amendment rights. Again, you will see this come up later in the textbook, so keep this information in mind when it comes up at that time. The Fifth Amendment also provides that a person cannot be deprived of life, liberty, or property without due process of law. This comes up quite a bit in the employer-employee relationship with municipal agencies, and these due process rights will be discussed in greater detail later in the text. The Sixth Amendment provides the right to a speedy trial, which can be a relative term given the sheer volume of cases that must be addressed by the average court, along with the right to legal representation if accused of a crime. Believe it or not, however, this right is not automatic and attaches only at critical stages within the criminal proceedings. Such a critical stage is a custodial interrogation, which is why criminal defendants are required by the Supreme Court to be notified of their Miranda rights prior to any custodial interrogation. That brings us to the end of this chapter. We covered a lot of information, so do not hesitate to rewatch any portion of this presentation or revisit topics within your textbook as necessary to assist your understanding of criminal laws that can impact firefighters and EMS providers. To summarize what we covered, consider these bits of information. A crime is a social harm that the law makes punishable. With that in mind, the ultimate goal of criminal law is to limit or reduce the amount of harm suffered by society due to the wrongful conduct of others. There are essentially 4 theories employed when punishing people for their crimes: deterrence, restraint, rehabilitation, and retribution. When defining a crime, the law must identify both a bad act, or, in some rare cases, omission, that accompanies a bad mind or bad thoughts. The Model Penal Code recognizes 4 bad mental states, the bad mind component of a crime, that give rise to criminal culpability: purposely, knowingly, recklessly, and negligently. While there are federal crimes, the majority of common criminal actions are defined by state law. Examples include homicide, burglary, assault, battery, trespass, sexual assault, kidnapping, arson, and various types of inchoate crimes and accomplice liability. Depending on the specific crime and the factual circumstances surrounding its commission, numerous defenses may be argued to alleviate criminal culpability. As far as firefighters and EMS providers are concerned, these defenses routinely include consent and the fact that laws typically empower them to perform their duties. Thus, typical illegal activities such as trespass, criminal damage to property, battery, false imprisonment, and others may not be only legal but encouraged given the societal benefit of those activities when performed by firefighters and EMS providers during the course of performing their duties. There are times when an unwitting firefighter or EMS provider may infringe upon a criminal defendant's civil rights or other constitutional protections, so knowledge of criminal laws and procedure, especially as they apply within your state, are important. There are several constitutional amendments that have a direct impact on the criminal process. The 3 most important are the 4th Amendment, which prohibits unreasonable governmental searches and seizures, the 5th Amendment, which guarantees the right to due process and the right to not self-incriminate as part of the criminal process, and the 6th Amendment, which provides criminal defendants with the right to legal counsel during critical stages of the criminal process. That wraps up our discussion about criminal law. While firefighters and EMS providers must be knowledgeable about criminal law to a certain extent, most of you will never have a run-in with the law beyond the occasional parking ticket, moving violation, or other minor infraction that typically is not even considered a crime within your state or particular jurisdiction. Your prospective contact with potential criminal defendants and the criminal process from that perspective may be limited as well. Where firefighters and EMS providers have the greatest exposure to legal risk is on the civil side of the law. In the next chapter, we will discuss civil law and the potential impacts it can have on firefighters, fire departments, EMS providers, and EMS agencies.